offences, provision, procedure. I have mentioned some offences, provisions regarding that, and procedure. Section 489E of IPC has punishment of 100 rupees. Section 510 of IPC has punishment of simple imprisonment for 24 hours or fine or both. Both sections are triable by magistrate of first class. Section 500 is simple imprisonment for 2 years. Offense is non-cognizable, bailable, compoundable, but triable by court of session. Section 493, punishment of imprisonment can be extended to 10 years. Offense is non-cognizable, non-bailable, non-compoundable, but triable by the magistrate of first class. Cognizable, non-cognizable, bailable, non-bailable, triable by which court? All these things are mentioned in first schedule. Column 4, cognizable, non-cognizable, column 5th column, bailable, non-bailable, and 6th column, triable by which court? In this chart or in this whole whatever I have made, I have mentioned offences. The provisions regarding that means which offense is cognizable, non-cognizable, triable by which court, their nature bailable or non-bailable, types of cases, summary case, summary trial, summons case, warrant case, and trial by the sessions court. Summary trials, summons case trial, triable by magistrate. Warrant case trial, triable by magistrate, and the trial before the Honorable Sessions Court. And also the powers, means which court can pass which kind of sentence or punishment. The High Court can pass any punishment, can sentence any punishment authorized by law. The Sessions Court and Additional Sessions Court can pass any sentence authorized by law, but the sentence of death shall be subject to confirmation by High Court. The sentence of death passed by Sessions Court and Additional Sessions Court shall be subject to confirmation by High Court. Then the Assistant Sessions Court, the sentence, so Assistant Sessions Court can pass sentence up to imprisonment for a term not exceeding 10 years. Then Chief Judicial Magistrate, then Magistrate of first class and Magistrate of second class. Chief Judicial Magistrate can pass sentence not exceeding term of 7 years. Magistrate of first class can pass sentence of term not exceeding 3 years, and Magistrate of second class can pass sentence of punishment not exceeding imprisonment of 1 year. The JMFC can pass sentence of fine up to 10,000, and in Maharashtra, according to amendment of Maharashtra, JMFC can pass sentence of fine up to 50,000 rupees. The Judicial Magistrate second class can pass sentence of fine up to 10,000 rupees according to Maharashtra amendment. The Chief Metropolitan Magistrate have same powers as Court of Chief Judicial Magistrate, and the Metropolitan Magistrate, the Court of Metropolitan Magistrate shall have similar powers as the Court of Judicial Magistrate first class. I have also given the hierarchy in which courts are given. Then the executive magistrates, also stages of commission of crime, intention, preparation, motive, intention, preparation, attempt and commission. When any incident happen, something happened, what will happen after that? Let's say we will assume that incident is cognizable, non-bailable, travel by court of sessions. The punishment is for 10 years. The information, who can register the information of such offense? Anybody can register the information of such offense or any offense. Police will take cognizance of that offense. Section 154. Information in cognizable offences, and 155 is information in non-cognizable offences. Police officers or the police officer can start investigation without permission of the magistrate in cognizable offences, and in non-cognizable offences, police officer cannot start permission without the cannot start investigation without the permission of the magistrate. Let's say the FIR, about FIR, lot of information there is. I will make it another video regarding FIR, because the FIR, particulars of FIR, who can register, how it will be registered. If FIR is not registered by the police, what we can, yes, if FIR is not registered by police, then the informant can make complaint or send a letter to the superintendent of police in under section 154(3), can send letter to the superintendent of police. If superintendent of police not responded or not take any cognizance, then the informant can reach to the magistrate to file a complaint. Under section 190, the magistrate will take cognizance of the complaint, and upon submitting some evidence and making submissions, if court is satisfied with the complainant that there is some substance in that complaint, then, and if necessary, the investigation is necessary, then the magistrate can direct the police officers to start the investigation under section 156(3). That is the cases register upon private complaint, and then the magistrate will issue directions to the court to start investigations. From there, when incident is happened, FIR is registered, or if FIR is not registered, then this process, here investigation start. If the FIR is against known person, means if name of the person is mentioned in FIR, that person can go before the court for quashing of FIR. Investigation starts under in section 157. The procedure of investigation has been given. Then during investigation, if it is necessary, the investigating authorities will arrest the person. Investigation is going on. The arrest, procedure of arrest is given here. The person is arrested in according to section 41, and in 41 to 60A, section 41 to section 60A, the procedure of arrest, how arrest to be made, has been given. In section 167, the procedure when investigation is not completed within 24 hours is given. When investigation is not completed within 24 hours, the person is presented before the honorable magistrate, or in special cases, I am talking in general, but if it is special act, the person will be directly forwarded before the honorable special court designated for that. In general pardons, the accused person, the arrested person, will be produced before the magistrate for custodial remand. Magistrate can pass custodial remand not exceeding term of 15 days. In many of the cases, police official ask or demands the remand of the person for investigation purpose, and then they submit before the magistrate that the investigation is completed, now the person can be shifted to the magistrate remand, magistrate custodial remand. Likewise, if in many cases police official demand 7 days police custody, 5 days police custody, but it is upon magistrate how many days custody the magistrate will give. Then when the person is transferred or ordered to be shifted in magistrate custody or remand, he can apply for the bail, procedure of bail and anticipatory bail. Regular bail means when he is not arrested, the anticipatory bail, and when he is arrested, the procedure of regular bail has been given in section 436 to 439. There is also one another thing. During investigation, the period for investigation is for say offenses which punishment is for life imprisonment or death. Such offenses charge sheet or the final report must be submitted in the court within 90 days, and offenses which are not punishable for life imprisonment or the death, such offenses charge sheet, the final report may be submitted within 60 days. So if in such cases the period is exhausted, the time taken by investigating authorities is beyond 90 days or 60 days, the default bail is granted by the magistrate to the accused person. In investigation, if when any person is arrested, if any article or weapon is seized from him, his clothes are seized, means if a murder has been committed and he wore the same clothes which he wore at the spot of incident or occurrence of crime offense, then that person's clothes will be confiscated, will be seized, and the receipt of such seizure will be given to him, muddemal. Under section 27 of Indian Evidence Act, the accused person's memorandum form is filled, means from police station he will show to the spot of incident, then he will narrate the spot of incident and he will come back to the police station. The whole procedure is given in accused memorandum form. In charge sheet, separate video about charge sheet, the final report I have made, but in charge sheet or during investigation, police will examine the witnesses in section 161, record the statement by recording of statement by magistrate, section 164. Then if mobile phone is used or the location is important, then CDR, SDR, correspondence regarding that. Then if any weapon is seized and blood stains are there or any DNA sampling needed to be done, that weapon and the test sample will be sent to CA for forensic report. Then any article or weapon seized, then clothes seized, their sampling, then letter or any other materials which are there, which are needed to prove the case and which are needed for evidence, will be collected. All the papers regarding that will be made, and the whole procedure means search, property search, seizure, arrest, surrender form, the accused memorandum form, remand, medical examination of accused, medical examination of victim, inquest panchnama, CDR, SDR, spot crime detail, test identification parade, statement of victim, informant, the statement of witness, supplementary statement, CA report, video footage, audio clips, photographs, letter, article, weapon, clothes, test sample, and if the person having criminal antecedents, that report as well, and whatever necessary for the case purpose, the investigating officer will collect all this thing, make a compilation of that, and the whole set the final report by signature of the officer in charge of police station. He will send it to the magistrate. During investigation, if investigating authorities found out that there is lack of evidence or evidence is not there against the accused person, the investigating authorities can release the accused person from the case under section 169 and prepare, just like the charge sheet final report, they will prepare a summary report. The offense means, in this case we assume that the offense is triable by court of sessions and have punishment of more than punishment of 10 years. In general cases, if it is special act, that the charge sheet, the final report will be sent to that court directly. So this matter, the charge sheet or the final report, is submitted before the Honorable JMFC court. JMFC court will summon the accused person to appear before the court and give all the copies of the investigations, means the investigation papers, the final report submitted by the prosecution's investigating authority, will be a copy of that final report will be given to the accused person. After that, the committal of case procedure will be done. Section 209, the commitment of case to the court of sessions, because this offense is triable by court of sessions. Charge sheet will be submitted before the Honorable JMFC court. JMFC court will summon the accused. If the accused person is out on bail, he will summon or send letter to the jail authority to produce the accused person before the Honorable court. When the accused person appear before the Honorable court, JMFC court, the court will give him a copy, give the accused person a copy of the final report, charge sheet prepared by the investigating authorities, and after that the case will be committed to court of sessions, because it is triable by the court of sessions. After committing the case to the court of sessions, the public prosecutor will open the case for the prosecution. The accused person can file discharge application. If the court allowed and discharge him, he will discharge, and the court, after that, if the discharge application is rejected, the court will frame the charges. After framing of charges, the public prosecutor will give the list of witnesses, the persons or witnesses mentioned in final report charge sheet. Out of those 2, 5, 10, 15, the list of persons the public prosecutor will give to the Honorable court, and the copy of that to the accused advocate, that these 5 or these 10 persons we are calling for the case purpose to prove the guilt of the accused person. Opening of evidence for prosecution. In that evidence for prosecution, examination of witnesses, chief examination of witnesses, cross examination of witnesses, and re-examination of witnesses. Documents are exhibited during that period. The whole set of charge sheet or final report is not exhibit. The only selective parts, selected statements, selective pages, selected articles are given numbers, and exhibits given. Then the public prosecutor will examine in chief the witnesses. The accused advocate will cross-examine the witnesses, and if it is necessary, then re-examination. After this stage, examining all the witnesses of prosecution, the court, if the court wishes, section 313, court will examine the accused. It is not mandatory, but if the court finds out that prosecution as lack of evidence, then court will examine the accused. The examination of accused will be in question answer form, and it is not on oath. Oath will not be given to the accused person who is standing on box for 313. Court will ask question in question answer form. It is not mandatory to give answer, and the answer given by the accused person will be considered for acquittal, but not for the conviction of that accused person. Then the defense counsel, the defense will submit if there is any evidence, they will submit if there is any witness, they will produce before the court, and the chief examination of the defense witness will be conducted by the defense advocate, accused advocate, and then the public prosecutor will cross-examine such witnesses and re-examination if necessary. After this whole procedure, the evidence will be closed and matter will be for final arguments. Public prosecutor will make arguments why it is necessary and how the offense committed and things about that, and he will make argument, and then the defense counsel will make argument and the judgment of conviction or acquittal and the punishment.